Coupled with regular inspection of police stations and other places of detention has tremendously enhanced the fundamental rights of persons in detention. This has illustrated narratives on detention practices and treatment of detainees in our education. Finally, so it's therefore imperative that to sustain the implementation of this oversight legislation, all the critical stakeholders must observe all these measures discussed above and those who keep their contemporary rules cautiously and effectively. The SAC government should also provide a number of environment and all the necessary facilities and logistics for effective implementation of not only this oversight inspection, but the whole provisions of administration of the Criminal Justice Act or law. Thank you for listening. Before I sit down, after the inspection, there are 3 forms that magistrates must submit. You should submit 3 forms. Number 1 is the detainees questionnaire. The detainees questionnaire contains all those questions. We already stated those questions. So at the station, you fill all these questions. You must fill the questionnaires properly, because one of the things you are going to return. So you have a Form A, it's a reporting form. That's the summary of all you observed. Go. This one is questionnaire. This one is questionnaire form. These are questionnaire form. So many things. Yes, these are questionnaire form. Yes. Once you fulfill them. Yes. Then, after that questionnaire, then we have Form A. This one about observation that either High Court judge or magistrate just go on detention facilities. You specify name of station, nature of facility, gone, address, name of visiting judicial officer, gone, the division, other delegates that followed you to state, name of officer in charge of the police station, designation rank, environmental condition of the place, maximum cell facility, the capacity to state, current cell facility to state, number of persons in the cell, gender, male, female, others, child, persons with disability, if the child is still attached to the particulars, there's a schedule to that effect. Was anything removed from the cell facility in the last 48 hours? Yes or no? If yes, please provide particulars of the domain removal. Section 3, special custody area. This one going like within the facilities. Then the rank, the numbers, the number of the new person, any other age, maybe how many persons, disability, agencies, the amenities of the self, social facility, toilets, lighting, ventilation, and classes of arts, medical specific, observation by the district judicial officer, collection of the self, detention facilities, because by that time we have finished the touring the place, you will have the observation. Please provide the general observations as to the physical or mental condition of the detainees. We provide them. Go on. Then please provide specific observations as to the physical, mental condition of particular detainees. If a particular of them, any challenges encountered with current detainees, any challenge we speak them. Records provided by officer in charge of station officer. Now, that section 51 mention records. Sometimes they may not provide all of them. Anyone provided for you, you just state them. Issues raised during interaction with officer in charge or station officer. Yes, you know that. Issues raised by the detention center, officer in charge, level of cooperation, for good, excellent. Was any education facility for people? Then from them, this is the second form. The first one questionnaire, this one complete, then you fill that one and fill this one. Then the last one is register for delegates accompanying chief for the magistrate during the judicial inspection. These are the people, legal aid, members of the SCGMC, members of the civil society that accompany the place of an address, name of the magistrate, name of the officer in charge, then their number, names, the organization the person is coming from, phone number, email, and signature. So when you fill this one, you also attach it. So this is the schedule referred about the people with disability. That's a particular of children or people with disability. We mentioned it last time. So it's accompanied the form, the other second form. You fill this one and attach it. Then at the end, that is the same. This form. This one is form 4, visiting magistrates and high court. This one is a summary. At times, I think we still include this one. We still include it. So we still include this one. It's a summary. Predominant offenses, that is number of detainees attended to. Predominant offenses, detainees were alleged to have committed. Wait. This is not to be recording all these things, just number of offenses. If it's murder, popularly speaking, or theft. So you say whichever one, or you specify the ones, because you can them and you know all you observed the predominant offense. Yes? So you state that one, giving the other one. It must not be in the box. You can just state it and provided you record the property. Gender distribution of detainees, number of male or detainees, females, which indicate the age distribution of the detainees. Have age brackets, the number of detainees, those between 0 to 7 years, those between 8 to 12 years. So you indicate that. You indicate the number of detainees unlawfully arrested, number of suspects detained beyond custody, time limit, number of detainees granted bail, number of detainees without legal representation, nature of the orders made or directive issued by police, taking a number of affected. Then, wait, this one now, the orders the magistrate made during the discussion. Now, the order, how many detainees did the order affect? 1. Order of arraignment, state the number. Order of remand, state the number. Order refusing grant of bail, direction for improved health care, order releasing persons illegally detained, direction for the released persons alleged to have committed an offense or not, direction of the separation of minors from adult detainees, direction for the release of any other debt on each person and others. The number of persons in their order you make affected, you state them. Then the general comments and observation, and you state them, then you sign. Then this one is another, that's one transportation students. There's a form, and how we do it is that when you want to go, when you finish, you go and get the form. When you fill all these forms, then you fill this, you fill this last one for a fee. You fill this one and attach to it and submit. So that before they give you the money, at least they will have seen your report that will be listed and everything. And they give you the stipends. And that's why. So, and I hope that as time goes on, it should be located here. And my love, Honorable CJ is here. And I thank you very much, and I hope that we will continue to encourage our magistrates to continue to do this dutifully because it's part of their job, and also assist them in one way or the other to improve on their satisfaction. Thank you very much. questions, please. Say questions, comments, contribution.
My name is ASP Michael from DCO London South. The issue of the detention of a long detention of suspects. When we have a case of somebody committing offense from, let's say, from the Eastern part or like Owerri or Anambra, so when as they go for this job, they ran back home, and the person, somebody shot him and came home and reported. And we arrested the person. For them to come out, the police from the rest of the come. So almost a month they come. So in this case, how goes to?
Sorry, the person where?
Like in Imo State.
Imo State, yes.
Somebody shot him here. They ran back home. To Plateau State here, just here.
Okay, just okay.
Yes, sir.
Okay, how to get the person?
And the policemen, when we called, they said, we should detain the men they are coming. And up to now, and the suspect is still with us. How are we going to do with us? In case of a magistrate visited, how can we work on that?
Okay, we were arrested there.
We arrested him here. Yes, sir. He committed in Owerri. He ran, but somebody shot him in Owerri. He needs to come back and said he shot somebody and he ran home. And we arrested the person for it. Called the policeman. He said, yes, they're looking for him. They're coming. Really come. Up to now, the suspect is still. How will we do that suspect?
Okay. When the person was arrested, there was a shorty in Imo. Yes, and he came here. I think in law, when there's a shorty and the person fails to appear, efforts should be made to get the shorty. It's not so. And when you are giving conditions and give condition of saying that a shorty must be produced, I think they are setting some amount of money that go with it. It's not so. So we used to have problem with this case with the police. I have to say it here. The police most of the time when they don't see the shorty, when they don't see the offender, they will arrest the shorty, bring him to court for screening an offender. Most of the time, that's what police does. But that is not the issue. No, it's wrong. Because if you arrest the person for screening offender, at the end of the day, you will not succeed. Because the ingredients for screening offender will not, it's totally different. It's not there. So, they want to do this for official of the bond. The person took a bond before he was released. He has to forfeit the bond, and you come to the court, magistrate, there's a procedure for official bond, and which you must arrest the shorty, and you must come to court to forfeit the bond. Then you pay bond, and at the end of the day, you must pay that amount. I don't know if you fix a lot of amount, if it's millions, it's very high. You must forfeit it. And if you forfeit it, then they are just to continue to search for the offender until you place the offender. So that's normally the. You want to say something? So that is not. I have not yet answered the question. I have not answered the question. What I was just trying to tell you about the short. Now come to the questions.
My name is Sondolale. This one. What this one says that somebody commit offense in Imo State, and then the police in Imo State, they now contact them, and the suspect is just here. They now arrest him. So they now contact, you have arrested your suspect. Go and call the suspect. The police will not come in time, and then two people now go to that police station. Okay, who is this one? Where the police that give for information that their suspect is here. And then they not one carry the suspect. That's what it is.
Yes. Now, in this case, the person is here being detained here. Yes. Now, the police, the magistrate has now come and discovered that the person has been detained here and for a very long time. In that case, what will the magistrates do? Yes. That's what I'm trying to hear. Now, for the question now, for the answer, magistrates, before coming, giving power to exercise. The power is that one, he can grant bail, two, he can order arraignment. You understand? So the order the magistrate must exercise is to go on given to him by the statute. And that is what we do in this respect is to want to order arraignment immediately. Eh? Without a complainant? No, not complainant. No, normal complainant will not stop you from arraigning somebody. He will not. He will not. The jurisdiction in criminal proceeding is that if somebody commits an offense, that you look at where the offense is committed, where is partly committed there or partly committed here. Secondly, where the consequences ensued. Yes, and also where the person is finally arrested. In this case, the court in those areas, two areas, can exercise jurisdiction. For instance, as you said, they arrested in Imo State,
He committed
offense,
the offense in Imo.
yes,
He committed the offense in Imo.
and he ran to this Plateau State.
He jumped there. He jumped there, ran to
Plateau State, where he was arrested.
And the security men on Plateau
Arrested him, yes.
And I think there is a fellow or two on the police institution. Now that you have arrested and it's with you, you must ensure that your colleagues in Imo State take him back to Imo State.
But why can't you listen to them?
You should release them back to Imo.
Well, no, even before, because obviously you're supposed not to be detaining the person. You're supposed to liaise with them, and that's why you signal to them. They refuse. Only them are refuse. Okay, but I think police is one, is it also? Can't you take him to that place? No, wait, you will intervene. What will you intervene? You intervene the suspect. He will disclose the normal complainants, disclose everything to you. It's not so. From there, you can reach out to whoever is necessary. And also ensure you take him to that place. With that, let me tell you, because when we are still detaining him, we are detaining him illegally. You understand? Of course. Constitution says you can't take more than 48 hours. And they are still detaining him. So to ensure that you do not infringe what law says, you make a frantic effort. That's what I'm trying to say, that we make arrangement to take him to that place and hand it over to. You don't know how to make arrangements. You know. No, what you do in this circumstance is that you make sure you contact them and you record whatever you discuss. When you record, you grant you them. You understand? Of course. If you cannot take him to that place because you don't have the logistics and they have refused to come, what you do is you make sure you. Which offense is not available? Is it corporate homicide?
You said he was on bail. Hello, did you say the person was on bail here and run to Plateau? He was already on bail, right? Yes. Okay, sir, there's what the police call a cooperation. Hello, let me speak. Okay, you see what they would have done, the right thing they would have to do in that stage will have obtained permission to travel, to get come and arrest the suspect. They will have come down, you will have helped them monitor to get the address of where the suspect is. And when they come down, you assist them to arrest.
What are you saying?
But in the case that you are already, in the case
I think the court, the problem.
since you are already arrested, you go to the magistrate, obtain a detention order, keep the person. Why don't
The last answer you gave us is what we decided we might do. So since the day come, we have a reliable somebody to certificate, depending when the people come. And that's what we did. So what is it?
No, but see, wait. See.
I just want to add to what he said. There are instances like the scenario mentioned. The first option is what they did. The second is to immediately send a report to the magistrate overseeing the visitation. And the magistrate now will use the discretion given to him by law to either order the arraignment or grant him bail. And in that situation,
I said all this before, but no, not you say you have been granted bail before. I think the problem is from those people from the movement. They suppose also to look for the shorty. It's even the duty of the shorty to be doing all these things. Because somebody is on shorty, the essence of shorty that you're undertaking to ensure that the person that's been released is made available to the authorities anytime it's needed. It's not so. They're supposed to do that. So shorty is supposed to spend money, come and do the proper thing. Otherwise, you answer for it. But since the police there are afraid, the shorty is not coming, and he's still in your custody. I told you that to continue to detain the person is an unlawful detention. That you must do something. Is either you release on bail so that anytime they want you, the shorty here will produce skin. You see, and another one, if a magistrate is also on a visitation and sees that type of person, the magistrate can still grant bail or order you to arraign the person before the court. When it goes to court, court can make necessary orders. That is what I advise. Any other question?
Once more, my name is Mr. Bohale. So, I'd like to see my life. I'm so excited. You see, my people, that support me in discussion. There's a man that is our money, police money. This man, what I want to say is that you said that they should not arrest the sorting. Some of people, they don't even know sorting. They don't know. They don't know the sorting. This man chop our money. We now have to be involved for Benin. When this man is not seeing, there's somebody that endorses stand for me as a sorting. They now arrest him. I'm not sure. I mean, the people don't know. They arrest him now. Yeah, the top police our pension money. Oh, he's a civilian. So this man now runs to the Republic of Benin. He cannot come, they now arrest. So that sort of man now is a sick man. That's rep. I don't know. I think we don't know. So as they don't see this man, they now arrest sorting. Sorting. The reason why I come up that you said that it's not good to arrest sorting. That you said it's here. Okay, now what I want to ask what is the outcome of the case up to now? What is the outcome of the because that's our money that they don't chop their money for nothing now. What is the outcome of the money? That's my question.
Okay, thank you very much. I said I did not say it's not good to arrest a shorty. I said that once somebody comes forward to shorty somebody, he's taking his vow, he's making a commitment that I'll make him available. And if the person is not seen, it's now his duty to get the shorty to fulfill the bond. Because there's a bad bond you give to him, he fails. In the sum of amounts, also amounts of money. The essence of it is that once the person is not seen, the offender, or alleged offender is not seen, the shorty is to forfeit that money to the federal government. In short, there's in my book, I don't know, trial procedure in my state court under the criminal procedure code. I don't know, so my state may have it here. So in those things, what you do is to ensure that that person fulfills that bond, he pays that money. What I alluded initially that I said that instead of you calling on Shorty to fulfill the bond, what you usually do is that you arrest the Shorty and bring him and arraign him for screening an offender. That's what you usually used to do most of the time, which you will fail at the end of the day. And that's not the proper procedure. The proper procedure is that once somebody fills a bail bond and fails to keep to that bond, he must fulfill it. He must pay the money. Once he pays the money to the if 1 million, 2 million, once he pays that money, then his obligation ceases. It's really a duty now to get warrant and look for the offender anywhere he is in this world and bring him to face the law. That is the procedure. You understand? It's for you to go and look for him. But he must fulfill that body. So it's the Shorty that even try to make sure that he gets that person. And that's why before someone takes a bond, ask him, he knows this person, the implication of taking a bond, what he's going to face if the person escapes, and all these things. So that if he knows all these things and goes forward to feel it, obviously he must answer for it. That is it. You understand? And if it comes to court, there's a procedure that you follow to ensure that bail bond is forfeited. The procedure is very clear. Thank you.
Sorry, I'm going to retract. Now, in the event that the Shorty is unable to produce that live song indicated on the bond, what do you do to him?
Yes, the procedure is one, you must evaluate Shorty. It's now in the court, you have to bring it to the magistrate court. The magistrate court will now give you opportunity to produce the person. If you face, you tell him to show cause why he should not forfeit that bond. He must tell you the reason. He may show you reason, genuine reason. If he show you the genuine reason, there's something we call the remission. You can reduce the amount. If it's 20 million, you can reduce it to 10 million. If 1 million, to 5 million. In this case, we have found out that the person was very diligent, ensuring that the person does not escape justice. In a real situation, you can remit. But if you find out that he contributed or he was not challenged, he showed not challenge that, you must pay the whole amount. And the moment you order him to pay the amount, he must pay it. If he fails to pay it, the procedure that you follow is that you proceed against his movable property. You execute it. What is called his release, redress, execution. So the way execute civil proceedings. Then you go after his movable property to execute, attach them, and sell to recover the money. If you have not recovered the full money, you go after the landed property and sell to recover the money. If you do all these things and you could not recover the money, then the person will be sent to prison for 6 months. It's a procedure on its own, no longer offense. It's a procedure for forfeiture of bond. You are no longer yes, for forfeiture of bond, yes. Yes, for forfeiture of bond. Yes. Just approach the court for forfeiture of bond and procedure will be taken. You understand? Court knows what to do. What for screening offender?
Good afternoon, sir. From your lecture, sir, you say right of a suspect while in detention.
Yes, right.
In those days, sir, the suspect were being paid for 3 square meal in a day. But today, there's nothing of that nature. So what is the problem? Secondly, when a complainant brought a complaint to the station, and when you detain somebody, you cannot detain him without food. When you now talk of it, say, oh, you're the one to take care of this, he will tell you, say, okay, I have lost what I'm supposed to lose, then I'm now spending another money for feeding. What is the problem? So that is what I want the authority concerned to look into this. Secondly, sir. Yes, sir. That is the challenges we are facing. What is the problem? Yes, sir. What is the way out? Then, secondly, sir, medical attention of the suspect. where they said. You see, sometimes you get some of the hardened criminals, especially when the time you people visited the station, maybe that suspect is a hardened criminal, you will now pretend say, Oga has been sick. The police don't listen to my complaint. Then from there, sometimes the officers, they don't even listen to you. They listen more than the suspect than you, the officers. So the authority concerned to observe this. Thirdly, sir, in the station, there are some of the stations we don't have facility like water, because you can't stay in the station without water for the suspect. And we find it very difficult for the police at the station. You see, we have big toilet outside. In the process of taking the suspect outside, the suspect may run away. You see, and at times when it is night, when the suspect will have a hardened criminal, he will tell you, say, okay, I want to go to toilet, I want to go to toilet. And there is no facility for water in the station, inside the station. Then on the process of taking him outside, the suspect escaped. And the police will get the problem into themselves. What are the way out into this? Thank you, sir.
Thank you very much. This sounds very pathetic, actually. We know that is the problem. We know that police are facing. And that's why we say that that's the advantage of this oversight station. So that you know the problems that police encounter, the problem the suspects, what they suffered, and all those things, and the recommendations should be made to that effect. I remember one of the stations I did was in time, in lifetime. When I went, I saw the suspect. They said they have been there for 4 days. I said, what of feeding? They said that. I said, the police give you food. They said, police said they don't give us anything. I said, how do we feed since 4 days? He said, it's our relations that used to bring food for us. I imagine, I said, oh, which means if their relations are not here, then we will not have eaten for almost 4 days and more. So I felt it actually. And at the end of the day, I made it one of my recommendations that I submitted to CGMC, that this is what they are suffering. Because we know all these challenges that people are facing. Most of the time, you are facing them, and when you complain, it will go to the deaf ear. That's why this ACGMC, this station is very important, so that there's another body that will see to reapply and also ensure that there will be recommendations made to that effect. So what we do is that not only even Abuja, not to here, even Abuja, there in fact some police stations when you go there, they are very, very terrible. I was engaged in oversight station at former SARS Abattoir in Abuja. In 2019, we started it. When we went to the station there, we went there. What we saw so many hundreds of people jam-packed in a very small place. And the place was very stinking, very deplorable squalor in such a way that if you stay there for 10 minutes, definitely you might faint. So what we did, like we came back, our CJDS, Commissioner of Police, they now sent me and once the bill was told for us to be going to the SARS to decongest that place. So every week we'll go there. The first day we went there, we took out 150 inmates there, took them to Kuje prison, KP prisons, and Suleja prisons, from where the police will now charge them to court. And when we removed them, when they were going, they were killing us, praying for us, thanking us. I was wondering, people are going to prison, not that we will. It's just to go to prison where they will stay, so that they will charge them to court from there. So they were so happy that being liberated. The second day, we removed up to 90. We'll continue to remove them there from that SARS office. Because you go there, the SARS people are actually complaining. You see somebody that is almost dying. What of the medical facilities they say they don't have? Actually, they don't have. In fact, the one that even annoyed us was one, because when we put them at Kuje prison, we were doing it under remand. That's what we call remand proceedings, where you remand for 14 days and later it will be renewed. So when we put them in the prison, then 14 days, the prison officer, correctional center officers will come. So there was one, the correctional center brought from Kuje. The person was almost dying. We said, why should we bring this person? Why not attend to him? They said, the facility they have, they don't have a facility to take it. As even correctional center. So even them themselves are equally complaining. So it's a structural problem that we are all crying for. And I know apart from maybe the DSS are very few of the EFCC that have a very good medical facilities. Police in FCT, they call it the same thing. So it's a very big problem. What we'll do is that we always report this. Because when we finish our report, that the feeding is a very big problem there. And the officers, before I conclude that, people should be given necessary assistance, logistics, to ensure that all these things work. So we report it to this GMC. This GMC, the members in Abuja will have all this, the CJ, the Attorney General, the Commissioner of Police, the Immigration, all of them. So this thing has been submitted to them. We submit the reports to them. And they will sit and look at it. It's for even the IG, the member of the issue is the third person. So you look at it, and we are thinking that from there, proper things should be done. We as a magistrate, we equally feel for you people, and there's nothing we could do. And that's why we don't take this issue of reports, we don't joke with it. Because most of the time, you people, nobody knows all these things outside you people. And when you complain to your guy, they have so many things. Let me just really have so many things that provide their mind. They may not, but now we are taking it to a fuller, a bigger point, including your guy who is there to look at it. And I know so many things are being done in the police station in Abuja now. So many things that are improving to great extent. So, and I pray that such will equally be done here. And because I always say police is one, no matter where you are. So that's why we do the reports. And even though it pains us, but we're equally helpless in that regard. And we pray that we continue to ensure that we project that issues so that the authority will look into it. And even ordinary prosecution is a big problem. Ordinary prosecution, they will bring FIR to court and you grant bail. No fulfillment of condition of bail. Okay, take the person to prison or correction center. But if you say I don't have money, how can I for bail? All this is a problem. I said, why? They will tell you, please, we want to take him to police station. I said, take the police station again, because he has already been arrested before the court. So it's still an issue. You need to come and give evidence. It's a problem. After you come and give evidence. There's a way he will spend money today, God doesn't see or doesn't like go tell you, it's not my personality. No money is given. But the law, ACJ provides for witness expenses that should pay for any person that comes and testifies for these IPOs. We have tried to, that's what we are trying to do in Abuja. But the responsibility is given to the judiciary, that is here, the chief registrar to budget for it and have the money for it. When they tell you, they say no budget for it. And it's still a very big problem. So actually, we feel for you, and it has been a problem that has been there, and all hands must be on deck to ensure that we find a solution to it. Okay, not be so. Not be so.
SB Benjamin for his issue. There is this challenge that we do face. We arrest a suspect, take the complainant as a statement, the accused as a statement, then the process of prosecution, nominal complainant fail to come for the prosecution. If evidence. So at times, if you charge the case in court, the magistrate will reject insist that the nominal complainant must be in the court before they hear the matter. So what
please, the moment you record FIR and you take FIR alongside with the defendant that are accused now to court, and the case is mentioned, then it's all the prosecution to produce evidence. It's not so. Now, you make arrangements for your witnesses. The issue of the production of witnesses does not concern the court. who to come and give evidence doesn't concern the court. It's the duty of the prosecution to arrange his witnesses. If you tell the nominal complainant to come and give evidence and he fails to come, then if there is any other witness you have, give that witness to give evidence. If you don't have any other witness, give that people to give evidence. If that people finishes and you don't have any, tell court I have finished, I have closed my case. If you have closed your case, then the magistrate they sit down, bring the evidence, look at it, examine it critically to know whether it discloses any offense. If it discloses any offense, then you will charge the defendant. But if it doesn't disclose, you will now discharge. So it's not the duty of magistrate to be telling you that nominal client must be in court. The reason is because, one, the case is between the states, represented by the police and the defendants. It's not nominal complainant. It is only when a direct criminal complaint filed by an individual is filed, and that individual fails to come, that is when you discharge. You can't say you won't have, but you just do what you're supposed to do, discharge because he fails to come. Direct criminal complaint, not FIR or charge. So the moment the police is there for FIR, the state is represented, a party is there, and the defendant is there. If the defendant is not there, the case will not go on because he must be there. Unless if it's by direct criminal complaint, you grant bail and you face to court, you continue trial to the end. But before you punish or give evidence, you must come before the court. So that is the procedure. It's not the duty of magistrate to tell you that the nominal complainant is not in court. It's the duty of the prosecution to arrange for his witnesses. Their duty is to call you. You know, in my court, most of the time, police will find. And to come and give evidence, they say, this is nominal complainant, it's supposed to come and give evidence. Just, this is what the court is going to do. Simple. You cannot hold you responsible again. You cannot manufacture evidence as a prosecutor. Your goal is just to produce the witnesses that you see and you have. If you don't have any, come and tell the court, the case will be struck out.
My name is Benjamin Woke, DCO Barclay. You know, security outfits are now speaking out from every news and crannies of this country. We have hunters, we have VGN, we have neighborhood watch. I don't know whether you people visit these facilities. They have offices. Sometimes armed robbery cases, they will handle it. Corporal homicide, they will handle it. And if you go to the offices, you will see their cell better than policemen. They will detain somebody 1 week, 2 weeks, because majority of them they are indigenous, and the offenders are indigenous. They will settle these cases unless there's a linkage of information to the police before police will go and take over. So what? Know whether you people still visit them to know what is happening in that place. Thank you.
Actually, this is a unique area. In Abuja, we don't have such a place. We have not visited, we don't even have. But I believe before you have security, all the security, they must do it with the consent of the police. So they don't just set it on their own and start operating. Actually, I don't know that actually because we don't witness it in Abuja. But I believe that they should still be under you people. You're supposed to go and you're supposed to go there and establish it for them, not just for them for it to take place. And they answerable to you. You are the state. No, whatever you should know. You are the state. That's answerable to you. They should not do it without your knowledge. So that you control them. You control them. So for visitation without having a bit, I've not done so. I don't know whether the people here might say are doing so. But what I believe is that for any people have a legally known established security agents who will know in Nigeria that any other security state should take permission. I remember in my area, before they go to police to establish security for this thing. And they collect them, they ensure they will investigate and know the suitability of it and even the nature of it and control them. So I think people should raise questions to that, with the appropriate authority. They can't do without you. I don't know.
The commissioner of police used to say that to the DPOs. He used to say that they should coordinate the activities of the vigilante and other people. And you, the DCOs, if you are aware of such, you table it to your authority. Let them know.
It should not be more than this. I think that yesterday they called me about one suspect, neighborhood. They detained me in their office. They called me. I went and collected him and detained him.
Yes. Let me just come in here. Let me say something. Let me just say something. Really, the issue that the DCO have just raised is very true. Recently, the Plateau State Judicial before they went on the strike, I don't know whether civil defense are here.
Yes.
They're here?
Yeah.
Listen, I had to really help my DCO to clear issues like that of civil defense. I say, no, you don't just arrest people and come and treat them. When you arrest somebody, you do the right thing. By what? You take the person to court. What you're saying is very true. Some of them, they will just go and arrest. They will not go and prosecute. Let the person to court. I told them that's wrong. And I've been privileged, I've sat with so many DCOs in almost everywhere that I've sat as a magistrate, from Lantan, Kanamika, all over. And I always take my time, I will call them, just give them a little enlightenment on their roles, their functions. I do that to civil defense very well, because they will always yes that they have prosecutory hours. But I will tell but you have not been doing, they don't even come to court. Sometimes I will call their prosecutors. I'll tell them, you see police prosecutor, he always in the court, whether he has a case or not. But that of civil defense, they will not even see them in court. And the day that they have a case, the day they have it, they will just suppress. And they don't even know the procedure to even prosecute the case. That aspect, really, you need to be looked at. Because they are detaining people unlawfully. And we must take up those. I don't know of other agencies, but that of civil defense, we must be serious about it so that people will not be detained unnecessarily.
Okay, this is the question I want to ask. This vigilante, were they established by the law as of assembly of this now? Huh? So if you are not established by law, the position of the law in Nigeria is that the power of arrest is that anybody can arrest. And the moment you arrest, you hand the person over to police. That's the position of the law. Now, the vigilantes, they are not established by law. Even if they will operate, that's why I said from the beginning, you're supposed to regulate their activities. They can arrest, but if they arrest, they should hand over to police. That's what they should do. And I believe that if you allow them to be operating in that manner, obviously they will tackle on people's fundamental rights a lot. And at times, most of them, they are so powerful with certain powers, so many powers that can exercise that if you don't start from now, at least at the early stage, to protect that, there is a stage to which you cannot control them. Answerable to police, and but they must bring. They don't have a right to be taking anybody. Just stand over to the police. Then for civil defense is vetted by law. They have the power to arrest. I think they have given them the prosecutorial power now. Yeah, they can prosecute. I think the only thing we do with respect to the civil defense is for them to be enlightened. That the moment they arrest, they don't go in illegal detention. And also that they always arraign the suspect to court. And also the magistrate here is also place of detention to visit them. That's the essence of oversight visitation. So that all those areas, the people that are just arrested before the court of them, you go there and do the needful. Set them free. That is grant them order them environment, because the law says police station or other places of detention. Simple. So they tell people that don't forget that place. So what you do is that you bring it to the authority that the station is not only at the police station. That of a civil person is equally inclusive. So that when you go there, you order them, tell them to do
property. Right?
That's not bad. It's not only the civil defense only. We also have MDLE. Because I could recall when I was designated as a I'm just trying to give an experience, my own personal experience. When I was designated as the supervising magistrate Shendam Zone, I could recall going to all the detention facilities within my area of jurisdiction. And when I went there, what I realized was only the police that are even aware of the existence of the SAJL and the provisions of the visitation. When I went to the civil defense, in fact, the PO then was even surprised. He was not even aware of the existence. Exactly. He even asked me that I should please help him get the law, Administration of Criminal Justice law. I did, which I did. When I went to the NDLA too, which they have the power for detention, well, what I did was to introduce myself to them and to let them know why I was there. I took the forms that were given to me. I showed them, and they all appreciated my coming. What I'm trying to say in essence is that us as the magistrates, we have the duty to, on our own part, go and do the necessary things and the other activities, the other Ministry of Justice as they are doing now. In fact, I want to commend them. This is the first time I'm attending something like this. Because if we are doing something like this, training and workshop, all the relevant agencies will get to know their respective responsibilities. And in so doing, we will have a smooth sense. That's my own.
I think you said it all. So the first thing is sensitization. Please allow them to know. Moyo, I think who's the SGMC? Your colleague, the lady. Yes. You see, all these things they're talking about NDLEA, and others. So they're here. That's what I wanted to ask, whether you reached out to them. All the relevant stakeholders, always engage them. So that's why I said to ensure that we foster this oversight visitation, regular training and interaction. Very, very important. So I think that's the only thing.
Okay, sorry, I remain Assistant Commandant Bernard Monica from the Nigerian Security and Civil Defense Corps. I actually appreciate what is ongoing. For us, we are not surprised because, like you all know, civil defense is about the baby of the security agencies, about the list. So some of these things you're experiencing is natural. But with this kind of training that we're having, I can assure you that we will do better. But I also recall some times back, even a magistrate does not know that civil defense has the right to prosecute. So we had to take that matter up, and the then DPP had to intervene and educated that magistrate somewhere in the lower plateau here. I recall that I was in the center of that, and I find it very surprising and weird. And so if the law keepers don't even know about that, what then do you expect the divisional officers? Like the case this other council mentioned, I'm very sure that that might be a new divisional officer. Otherwise, myself and the Ministry of Justice had organized a workshop for all IOs, that is intelligence officers and divisional officers, concerning the actual law. And so for anyone who has said he has never seen, we have a lot of the copies, even the abridged version that the Ministry of Justice on the plateau produced. We have it and has been circulated. So I find it very difficult to believe that, but I'm sure you can always have such in the family. In any case, we are doing well. And I will encourage you to also visit our facility here at Abattoir. You will see something that you haven't seen before. Thank you very much.
So it's very clear, as I said before, you will have power to arrest and prosecute. But what you need to do in granting bail, I've been in this civil defense offices, when they want to grant bail, the conditions people give is always so high. In short, they're so harsh and onerous that
the person will find it very difficult to fulfill it. And the moment the person cannot fulfill the condition of bail, the amounts to no bail, he will continue to be there. Always try to mellow down to give a liberal conditions because
Your lecture talked about that. Your lecture talked about it.
yes, I noticed it even in Abuja. So some of them will just give conditions that cannot be fulfilled. So please, you look at that very well so that. So who is it? Okay, sorry.
I'm DSP Ware Egula. This is your I just want to ask this question because I used to have problem with my prosecutor. When the case suspect charged for prosecution, the suspect pleaded guilty to the charge taken against him before the court of the day, and he was sentenced to prison or remanded in the prison custody. Who is responsible for his transfer to prison? Is it police or court?
Transport of the. Anyway, the only thing in Abuja, how we do it is that the moment you give conditions, you grant bail. It's not only conviction, you could even grant bail and he fails to fulfill the conditions. They can't go home, they will take him to correctional center. Or you convict him and he needs to be taken to the place. Yes, the problem is that actually the police will always say they don't have the means to do that. What is usually done in FCT is that in every court, you have the correctional center people. They always come to court every day. They have vehicles. And if they're in court, and in almost every court, you have a correctional center person there. So that the moment you grant bail and you pay correctional fee, there's a need to take the person to correctional center. That person, even if the correctional center people are not there, their vehicle is not there, they will call them. They will call them, they will come and take them. It's the duty of the correctional center, correctional service to take the person. There's a protocol to observe before you can take somebody to prison. There's a protocol. Officers, also, there are protocols to observe before you put somebody in custody. So it's their duty to do so. But the problem we have is that they equally say they are handicapped. They don't have the vehicles. They don't have the means of accompanying all the courts. How do they do it? And there was a time where we had all this problem in Abuja. Because correctional center, even those we have, before 2 o'clock, they would have gone. Or 2 o'clock, they would have gone. And we continue to tell police, if you are bringing a fire, bring a fire very early in the morning. In the south, they call it overnight. This overnight is very early. That's the first thing the magistrate takes. So that the moment he grants bail and start sitting, there will be enough for them to make arrangements for shorty. So that if they don't have shorty and there's any need to take the person to prison or correctional center, that could be done as early as possible. But when you bring a fire around 2 o'clock, but then the correctional centers people will have gone and they need to take the person to the correctional center. It becomes very difficult. So if you come to the person, it is his duty to do it. It's the correctional center people that should do it. It's not even the function of the police or the nominal complainant. In fact, there was one that happened in Abuja was a time where my state put hands in his pocket and brought money to take this person to this place. And tomorrow there was a petition by the nominal complainant that the magistrate requested what concerns him about taking the suspects to correctional center. So it's a big problem, but what you should do, I don't know, the correctional center people, they don't go to courts here. They don't go to courts. Not regularly. Okay, maybe that's the difference. Okay. We have them that the people that take them.
Most of the time, they always complain that maybe they are vehicles, just the problem, funding saying the route of this thing. All the police, the correctional, one clear issue that's funding. Lack of funding.
They complain everywhere, even Abuja they complain. They want to do that, we'll do it on time and also call them to come because they must come to court every day. So it's not, officer, actually it's not your duty. I'm sure when you are leaving the station, they don't give you money to do that. It's not so. So it's not your duty, but still, you require to do the needful. Because if the person runs away, obviously, you'll be
responsible for that. You will account for that. You know, most of the time you need even to protect your image and your work. If you are looking for the proper thing to be done, at times you will not even go to work at all. Because there are certain things that are supposed to be done or put in place that are not done. So at times you do it even to secure your job and your image. But they will allege so many things against you if the person escapes. So we know it's a very big problem, but try to do your best. Why we hope that one day this will be done well. Thank you very much.
What I'll do, what I'll do is that maybe your questions will take them back and we'll answer it and send it back to you electronically, if that's okay. Thank you. So please, a round of applause for my chief of staff. He has actually made this GMC and the judiciary work very well. We have a very good relationship. Sometimes I think I abuse it a bit when I call him at odd hours. He say, I need you to present. But I want to say thank you. He has been very, very helpful and supportive. So please, another round of applause. All right. There are two more presentations about to be done. Mine is on the ACJMC portal, and the executive secretary will virtually train the last presentation on the reporting obligation. So we'll try not to take too much time. I understand this is Friday, and I need to respect our Muslim brothers indirectly. But I know they are here, so I have to show my respect to them. So, my name is Moyo Boluwade, ACJMC Federal. And one of the duties I do is to manage the ACJMC portal. What we did was, in the year 2018, we discovered that we need to move from one stage to another stage. We can't be doing paperwork for the rest of our lives. Having an executive secretary that is very innovative due to his experience in the UK, he felt that it's high time we move from paperwork to digital work, and that gave birth to the ACJMC portal. The ACJMC portal is a reporting portal for all criminal justice stakeholders. The correction reports, the police, the other law enforcement agents report, the judiciary also do that reporting. And the ACJMC portal was launched in 2019. We started it and we trained the police. Well, we trained some of the police officers and some of the magistrates on how to be reporting on this portal. And after training them, we also gave them feedback that they should give us feedback if it's very accessible for them, if it's very easy to them, is it difficult to upload records and all that. And they did that, and we went back with the support of MacArthur. We were able to upgrade the ACJMC portal, upgrade it in this level so far. And part of it is also that it's not just for FCT to upload. All over Nigeria can also access this portal. So our way is now introducing the ACJMC portal to Plateau State, and bearing in mind that we are coming back to actually train stakeholders on how to upload records on the portal. The idea is this. Thank you. The idea is this. We believe that if JAM and WAEC can move from paperwork to electronic, I think the criminal justice sector can also move from that level to electronic level. The police and even the magistrates, most of the registrars are actually uploading records. What you're actually seeing there is a little bit of the records being uploaded. It's way more than this, because due to the upgrade, we had to keep the backlogs, so they will upgrade it to a better. So now the records are uploading bit by bit. So what I'm going to do is just to show you steps of how we do it and how it works. We can even do 1, 2, or 3 practical examples on how to upload records. Now, the ACJMC portal has 2 main parties, 2 main people that actually operate on this portal: the super user and the sub user. Super user is just one person, which is the ACJMC Federal. The sub users are every other stakeholder, every other participant, coming from the DSS, the civil defense, each court, each police station, the corrections. What we did with corrections so far, we understand corrections have what we call SIMS, which is a correction information management system. So instead of retraining corrections again to upload their own records, we decided to create the two, this portal and SIMS. So we don't need to train the correctionals because they're already uploading the same records we need on SIMS. So what we did is link this portal with SIMS. So all that information we get from SIMS we get on our own. So now our focus is basically on the police, the law enforcement agents, and the judiciary and all that. So even the judiciary can also upload their own records of their returns too on the portal. It's accessible for the CJ to go through because actually the idea is not just for us to say we have a portal. The CJ goes through it, the commissioner of police goes through it. That's the beautiful part about this portal. Now, we don't allow people to see, like the CJ going through it is not definitely going to see the details of each suspect. Oh, Mr. John committed fraud. Sorry, is there Mr. John here? Mr. John committed fraud on this day. He was sentenced to 3 prison on that day. No, nobody actually needs to see that. What they're interested in is in data, something like this. If you look at it right here, we have this data. And if I scroll down, this is another illustration. This one shows the level of male and female committing crimes. I know more women commit crimes, but so far we have more males here committing crimes. And so then we also have statement taking room. This is how it's going to look like graphically for each person. So what we do in the federal, I'll create an account for whosoever I need to create for the police. Okay, which police? I believe there's a police division. I had sorry, I'm trying to remember the divisions I had in this meeting right here. Yeah, in fact, I'm trying to, I want to move here. That's my plan. So I'll create a certain access code for this DPO or this division for him to upload his own records. I can create a certain access code for a magistrate of his own division for him to upload his record. And that's the job of the administrator, the super user. He'll be able to assist the other sub-user. So there will be no issues of, I couldn't upload yesterday. I can upload today. I can upload tomorrow. What happened to my record? That's the beautiful part of this portal. So I think what I'll do is when we create an access code, let's say for the police, we pick the division, give them an access so they can be uploading records. The police can actually see what he has uploaded. If he wants to correct it, he can correct it. That's the upgrade we did on the portal. Back in the old portal, the police doesn't know if he has uploaded. He only sees a link that says your record is uploaded. He doesn't even know which record he uploaded. So if he has an error, he has to call. So we looked at it that this can't work. We need to move forward. Because if we could remember how Facebook looked like 10 years ago, it's not the same interface we are seeing right now. It made it so easy. I know a lot of people are not computer literate, but they know how to operate software, which they don't know how to even operate the computer. That's how they made the interface easier. So we also did that to make this one easier. So the website is actually www.acgmc.gov.ng. So I think what I'll do, I'll first log out. So I'm sure you have this right? So if you log in www.acgmc.gov.ng, this is the interface you get. This is how it looks like. And I've actually created an account, so I don't want to stress to create one account. So if you log in here, you first decide which role you take. So you pick the administrator, child welfare, directorate of public prosecution, EFCC, ICC, immigration, all the stakeholders, criminal stakeholders. For them, you choose the role you want. So that's why I say even if we have 200 police stations or 5,000 police stations, I'll upload it right here because everything goes to the cloud before we get a bigger and better database. So let's start with, since I love the camo uniforms of one right here, I wish you can give me one. I will start with the police. That we say we do with the police. Let's say we pick a state. I'm just imagining I've created an account. So I think I created one. So let me see. I'll say EFCC. I would say FCC. Hello? Okay, I've created EFCC, police. So I will put in email address and the password. Okay, no one. Yeah, because I put the wrong state, it didn't work. I didn't put that. So this is the dashboard of the police. This is how it looks. I've not recorded anything yet. This is how the dashboard looks like. The record I want is statement taking record. I may pardon platoon for STR, statement taking rule. Why we did this is because Abuja has 2 statement taking rooms in the FCT. So that's why we actually created. We know that definitely every state will have its own statement taking room. That's courtesy of ROLAC. They actually did 2 major statement taking rooms in the FCT. But I think the one we are interested in so far is the arrest cases, which is section 33 or section 49, and then terrorism cases and the remand tracker. The remand tracker works with the magistrate, so I can't touch that. The remand tracker works with the magistrate. So the way we did it is so that as you are going for a remand, the magistrate of your own jurisdiction is aware. So the tracker reminds the police and also the magistrate. So let's start with arrest. If we can go there. So can everybody can you see it, right? It's good, right? Okay. Okay. So let's say we start with the arrest and we go into this one. We want to upload a record. Now we go into the next icon that says add new arrest record. Right now it's blank, there are no records. This is the interface of the police. Now, the beautiful part is that police in this division is not interfering with police in another division. This is its own interface, this is its own what it's uploading. The only thing is that the super user can actually see this. So if we go into add new arrest, now we add the name of the suspect. We have John, we have his male, and then, all right. Now, we said, is there a reason for him to be in detention more than 48 hours? There's no reason, maybe he was released. We put nil. Now we say the date of arrest, put the date of arrest. Let's say he was arrested on the 7th of April, and he was released on the 8th. He was released the next day. Or let's say he was charged to court the next day. And the name of the police station, can I have a station in Jos that we can use? One name. Crispan? Crispan? There's a station called Crispan. Okay. Oh, G. Oh, DU. B-U-K-U-R-U. All right. We were there one day. So we'll put the inspector's name. Inspector. Can we have one inspector's name? Ali. Inspector Ali. And we say his case is criminal breach of trust, fraud, or theft. No, sorry, his status of the case is actually charged to court. Yeah, charged to court. Then his offense is theft. Yeah. And his remark, no remark necessary, this was charged to court. Then we click on submit. And then it shows successful from the data, successful data set. Automatically, if you want to actually check, okay, did this thing enter? Maybe just go straight to the dashboard If you look at the dashboard now, that's automatically increased automatically because of one data. It's actually just one data. By the time more data comes into shorting, and you can also go and check the arrests. Also go and check the suspect. How one suspect is right there. I want to believe it's actually simple and straightforward. Yeah, there's a customer, just one day. Just one day. So what now, by the time this comes on the display, we can actually show this is the criminal, this is how criminal justice is moving in this state, this is how it's moving in that state. Oh, justice is doing very good. Abuja is number one. We show that to developing partners, to the CJ, to the Attorney General, so they understand actually what's going on in their own divisions. If you go, I was privileged to go to the Comptroller General's office to see SIMS. Right in his office, he has his own dashboard to see all the states uploading records. I believe they are using SIMS. Yeah. So in his own office, he doesn't need to go to JOS. Yeah. He actually showed us on his own. Okay, this is what's happening in JOS. JOS is uploading. If JOS is not uploading or any other state is not uploading, you just make a call. What's going on? What's happening? So they're actually uploading and it's actually seeing that in the comfort of his office. So that's exactly what we want to do for this place. Are we good? Yeah. So I want to show how the magistrates or the judges uploads their own, let's say for oversight, because I know oversight is not that quick like this one. So what I do, I need to log out from this one and log into the oversight for magistrates. No, let me do that. Let's create for Plateau. This is how I create for Plateau. I'll put my own details. I will do this one. Now, if you were watching, my record has just increased a bit. So I want to create the user for Plateau State. Actually go to manage users. And these are the users we've actually created for other. We have the one for the judiciary, we have the one for the police, and all that. So I create one right here, create a new user, and I'll say, okay, say Jesse, since it's straight, I will use just Jones. I'll give him an email address. Just a fake email address, so you have access to it. So it's not a real email address. And the agency is judiciary, and the state is the two states. And I'm giving him advance. I put the phone number, which is actually his phone number. And that's cool. So I have created a new user for the judiciary for JOS. I will just log out from this one. So automatically the new user is coming here. You click on judiciary. It's going to click on Plateau State. And password. So this is for no record. This is the new judiciary, no record displaying with me. Now the person wants to start, and one day he went for oversight. He went for oversight. His oversight visitation at Ukuri. So he's going to add new sites. He's going to put his reference number, which is something like and then the name of the station. Is it Bubu or Bubu? And when we do the way we do it like this, since it's going in the month of April, it started from 1st of April, so which is going to be 1st of April to the end of April. But the day he visited was on the 14th of April. His observation of the station, very cooperative, very great station. Click on submit. That one is submitted. Now that's the first stage, because I understand that oversight investigation, he can go that day, he can only see 2 suspects. He can go another day, he can see up to 50. So it's done in a way that each oversight has its own list of suspects. It's different. Unlike records of arrest, which is from the 1st to 2nd, he can be doing it every day, depending on when he wants it. So now, once he has done this, he will first come to oversight. And as you can see right here, there's only one entry, no details inside. So what he's going to do is going to go to this arrow bar. These are indicators of what he can do. The first one is to edit the record. The second one is to view the record. The third one is to add more items. While the last one right here is to delete this record. So what you need to do is add more items. So you click right here to add more items. So now he's ready to add items to this place. Look at the instruction here. We have the state, we have the station, we have the date of visit from this period, from this period. It's going to have its own details, which is going to now add, it's going to say new oversight details. This is where he adds the name. And we have Jessica, we have Mary, we have email, we say charge to court or release on bail. Charge to court. So Mary was arrested on the 13th. She was confined that same day, right? But since they say charge to court, he was released on the 14th. Is it making sense? Or if there's any question, please let me know. So with that means number of days is just 1. Bail condition, none, right? Since it's charged to court. What's the offense? Theft. Then we click on submit. If we need to add again, we go back, we add, and to that same, the idea is to that same column, not to add into a fresh column, because you're adding the list of suspects and all that. So it makes it very simple. If you even come to the dashboard and look, the dashboard will actually change to one event. The same thing if we are doing judiciary returns, we need to add a new return, case brought forward, case. It's a very simple platform. So our plan basically is that, okay, in the next phase, with the support of Makato, we are trying to come to train everyone. Definitely we are starting with FCT now, your worship. That one is number 1. Can't, so that you won't arrest me. We're starting with FCT. So the idea will train on the new portal. That was the plan. We're training them on this upgrade, giving them new access so they continue from where they stop. And it's supposed to be provision of electronics, but until the new money comes from so that's the idea. So we'll train them. The next stage is to come to other states. And already, just it's our second home. So it's number 1. We'll have to come here first. Train everybody on how to use the portal before we go to any other state. So thank you very much. I believe. Please, Any questions? Or if you have any questions for my chief, so I just thought of you. We are in the same sheet too. Thank you.
Sorry, my name is DSP Simon Papechi. So I want to advise us back. I want to ask you questions on some challenges that we're facing. So, like in terms of signing of search warrant, we are finding some challenges during the time when court are on strike in terms of signing of search warrant. Secondly, when a policeman has a right to sign a search warrant during holidays or weekends, maybe when you wanted to embark on search warrant. These are the questions.
That's right. Okay, search warrant. When a magistrate is on leave, magistrates are. Okay, usually on strike. I think there's a provision in the Police Act that says the senior police officer can sign. There's a provision that if you look at their Police Act very well. Yes. It says a senior police officer. Yeah, right. I think from ASP. I think most senior from ASP can sign. Or Justice of the Peace can also sign. Yes, if officer from the ASP signs, it goes. You can sign. You check your Police Act very well. I'm sure there's a provision to that effect. So that is it. Any question to what he presented now? I think, I'm not doing this. If you see the agenda, I think that there is a police and law enforcement agency reporting obligation. It's supposed to be 12:15. I think that was practical session. You can just rush on it. It's not much.
So that you can sign out securely. Go and do account in and it's ready. So what's your details? This is what. So what's your email? L
capital B, small e, CKS, 78 at.
So maybe one-time password.
723 723 66. Start.
Duncan, eh?
No,
Where do I go? Sorry.
good order meeting. Speaker. Speaker. Okay, it's connected.
There's a provision under section 50 of ACJF, Plateau State. It talks about police quarterly report to the Attorney General. I think we are aware of that provision. So, it's at the section 29 of ACJA. They have the same provisions. It said that the Inspector General of Police and the head of every agency authorized by law to make arrests shall meet quarterly to the Attorney General of the Federation a record of all arrests made with or without warrant in relation to federal offences within Nigeria. The Commissioner of Police in a state and head of every agency authorized by law to make arrests within a state shall remit quarterly to the Attorney General of the state a record of all arrests made within or without warrant in relation to state offences or arrests within a state. 3. The report shall contain the full particulars of arrested suspects as prescribed by section 15 of this act. Section 15 is in respect of ACJ, but they have a corresponding provision in section. I think you see ACJ law, you will see it. A register of arrest containing the particulars prescribed in that section 15 of this act shall be kept in the prescribed form at every police station or agency authorized by law to make arrests. And every arrest, whether made with or without warrant, within the local limits of the police station or agency or within the Federal Capital Territory Abuja, shall be entered accordingly by the officer in charge of the police station or official in charge of the agency as soon as the arrest, and shall establish an electronic manual database. That's Attorney General of the Federation replace it to Attorney General of the state. That's what the law says. You see, it shall establish an electronic and manual database of all records of arrest at the federal and state level. So this is a provision. So that's section 50. That is to say, quarterly, the Commissioner of Police will prepare the record of arrest made within the state and submit to the Attorney General. And in recording it, section 15 states what we are going to record in that report. Go on. Then what it says that what should be recorded is that you state the alleged offense, the date and circumstances of his arrest, his full name, occupation and residential address, and the purpose of identification, his height, his photograph, his full fingerprint impressions, is okay, or such other means of identification. I know this one is very difficult most of the times, but we don't have the facilities. The process of recording in section 1 of this session shall be completed within a reasonable time of the arrest of the suspect, but not exceeding 48 hours. Any further action in respect of the suspect arrested pursuant to section 1 of this session shall be entered in the records of arrest. Then this one is talking about the reports the police make to Attorney General. Then there's another report again. Next it is called quarterly report. Yeah. Next it is called monthly report. Sorry. So that is the first reporting obligation of the police. Number one is to the Attorney General. The second one is to the courts, the visiting magistrates. The magistrate that conducts quarterly inspection at their division. You also prepare a report and submit to that magistrate quarterly. That is what is required by the ACGL of Plateau State. Now, in that, is that session. Start from the beginning. Yes, the second report from session 33. No, up. No, come down. Administration. Yes, go down. Yes. Yes. In FCT, police and other law enforcement agency report on arrest made without a warrant. Session 33. In FCT, session 33. Here. Session 50 or what? Session 50. It's session 50 here. Yeah. That visiting magistrate to pay your jurisdiction. You have to make quarterly reports to him on arrest made. In that case, an officer in charge of police station or an officer in charge of an agency authorized to make arrest on the last working day of every month, that is quarterly in Plateau, report to the nearest magistrate the cases of all arrests or suspects arrested without warrant within the limits of their respective stations, agency, whether the suspect has been admitted to bail or not. The report shall contain the particular of suspects arrested as preferred in section 15. We have already mentioned what the report should contain. Yes. Third one, the magistrate shall, on receipt of the reports, forward them to Criminal Justice Monitoring. Go on. Forward to Criminal Justice Monitoring Committee, who shall analyze the reports and advise the Attorney General of the Federation as to the trends of arrest, bail, and related matters. In fact, magistrates even FCC don't do this one most of the time. They forget that they're supposed to send it to the Attorney General of the Federation. The Attorney General of the Federation, upon request by the National Human Rights Commission, the Legal Aid Council of Nigeria, or non-governmental organization, make the report available to them. 5. Where no report is made in accordance with section 1 of this session, the magistrate shall forward the report to the Chief Judge of the state and the Attorney General of the station for appropriate remedial action. Where the police or other law enforcement agency fail to submit these reports to the magistrate quarterly, as in a Plateau State, then the magistrate should report same to the Chief Judge as well as the Attorney General of the state for appropriate remedial action so that they will take action to that effect. Now, with respect to the Federal Capital Territory Abuja, such report referred in section 5 of this session shall be forwarded to the Chief Judge of Federal Capital Territory Abuja and the Attorney General of the Federation. That's one FFCT. Then, now, this one is the form, the template for the report to quarterly report to the Attorney General, how it will look like. Yes, the reference number, Nigeria Police Force, the state command agency, the state departments, where appropriate, will state clearly. Then period of reports from so month or quarter a year. God, please find below a record of persons who were arrested by the police in the quarter of so quarter. Yes. Serial number, have name of suspect, you state the name of suspect, the occupation, you state it, residential address of the suspect, you state it, date of arrest, you state it, sex, age, the alleged offense. If a charge of the court, the date charged to court to which the suspect is charged, and the charge. So all this, they are what you state clearly in the report to submit to Attorney General, and thereafter you sign it. It's very simple form. Very simple. Then the one the police or other law enforcement agencies submit to the visiting magistrate, that's the magistrate that conducts oversight visitation, is this one, template 9. Police order now you rise to the supervising magistrate within your own district division. the name of magistrates, the court, or the area of court, their worship. The following is a report of the records of arrest made without warrants in the so police station or command during the period stated below. You state the period. Portion to section 33(1) of ACJ, 50 of ACJ law. Find below the names and particulars of persons arrested without warrants within this Marseille district and detained at the police station or other enforcement agency. We start serial number, name of the suspect, alleged offense, date of arrest, dates of release on bail or unconditionally. If that date of release on bail or conditional release, whether conditional release, if not released after 48 hours, if reasons, number of days in custody, status of the case, full names and ranks of the investigation officer. Okay, so this is just the report. It's a very simple one too. You submit it quarterly to the magistrate. So so maybe if you have questions, you ask me later on the report.
Mr. Suleiman Daoud will actually do his presentation virtually. That's what we are trying to connect. Hello, sir. We are ready for you now, sir.
All right. Okay. Thank you, Mr. Facilitator. Hello. Good afternoon, Your Worship, Your Excellencies, and your learned friends, heads of agencies, and my able secretary, and all the distinguished participants. I convey our best wishes from here, and also my apologies for not being able to be with you. I had to cover the home ground on few matters arising. But I'm grateful to my colleagues who stood by and ably representing us over there. Yeah, I wouldn't take your time too long now, considering you've had a very long day, and I think you've already in the mode of all the reporting obligations. But I thought it would not be complete without also interfacing with our correctional service counterparts. Having dealt with the magistrates and the police and law enforcement officers. So my presentation is very brief, hopefully, and it's just speaking to the responsibility of the correctional service officers in relation to the ACJL plateau and under the ACJA. So in my introduction, I'm sure the slide is being conveyed over there. Sorry, I may not be able to share my slide from here because of time, but I'm sure we all will be projecting the slide, and I have the introduction there. Considering that your law was also passed 2018, I see that the implementation is given to the JSRT. I don't know, I was hoping I would be on the ground to clarify what NATO is doing moving forward about this JSRT and not sinking into what we have in other states in terms of the monitoring committee. Again, I'm not aware whether there is another law you have reviewed your 218 law to cater for monitoring committee. I actually thought that you had an ACJS so-called. But having said that, I'm only saying that responsibility of complying with this provision of the ACJL in relation to reporting obligation by the correctional service will have to be taken care by a body which for all intents and purposes, we've had our own set of monitoring committee being responsible. But I take on board that your law is giving that responsibility to JSRT. And I know that you have a very capable secretariat and the secretary who are charged with that responsibility. So let's not take time further on that. I'm sure we can always discuss all that structural issue at a different platform. In due course. So we take the JSRT, Justice Sector Reform team is actually taking care of all of this. And we'll also be dealing with all that has been said in relation to the reporting obligation by the law enforcement agencies and by the police and obviously the oversight visit of the magistrates. It's a huge responsibility that we actually take very seriously, and we always enjoy that. That is the primary responsibility of any committee or anybody that is charged with that responsibility. And in this case, it is just Justice Sector Reform team. It is your responsibility to ensure that all of these reporting obligations are met, and that is why we are so-called the monitoring committee or monitoring team, because we go around to collate all of these reports and ensure and collate them, analyze them, and then we publish them. And that way it reflects the current position, the trend of the offenses, the trend of issues, the trend of detention, how compliance, and all the rest of it. That is the beauty of having a committee, and that structure framework is very important before we even talk about the nitty-gritty of what is expected from the officers in relation to compliance. Without having a very strong monitoring team that is taking the bull by the horn in relation to the compliance or ensuring compliance, then you will just be sitting on the face of the paper of the law, and that's not what we obviously striving for. And we all gathered here today to ensure that we have an effective implementation of these reporting obligations. And so that's why we're also adding the counterpart of the correctional service. And that has been, having said that, in relation to the structural framework for the compliance, for monitoring compliance, having stressed the importance of having that. So if we have a quick look at the provision of the Administration of Criminal Justice Law of the Plateau, and taking on board the Section 19 specifically of the ACJL Plateau, which speaks to the purpose of the ACJL itself, to the efficient and effective dispensation of criminal justice in Plateau. Then it is by all the Plateau State justice actors, criminal justice actors especially. It then makes sense that while we are doing all what we are doing, what is the end of all of this exercise of collecting all these reporting obligations? Because it speaks to the purpose and the application. Section 20 also speaks to the application of the law. So that is what we want to achieve, effective dispensation. That is the trigger point that we will also monitor. Are we doing well? Are we doing bad? Are we really making effort to ensure that we have a speedy dispensation and effective dispensation of criminal justice? This is why all our exercise is never in futility, and it is not, as some might opine, that it's almost a busybody. Why do we have to be filling these forms? Why do we have to be getting bogged down about these record debts? And what are we going to do about it anyway? Anyway, so let me go straight down to the provision, specific provision of the ACJL that speaks to what we are doing in terms of reporting and monitoring the activities is Section 126 of the ACJL, and that is where I am actually specifically addressing. Section 126 of the ACJL Plateau enjoins the controller, it says the controller general, but it's actually the controller at the state level and other officers in charge of correctional service at the state to actually to file a return on every 90 days. Every 3 months, quarterly, there should be quarterly return to file to who? To the CJ, the Chief Judge of the state, on the one hand, and to the Attorney General of the state on the other hand. That return is what speaks to what? The persons awaiting trial held in custody in the correctional centers in Plateau State. So people that have been awaiting trial in Plateau across the 20 days, we are meant to render that return to the Chief Judge of the state and Attorney General of the state. And specifically, it's not all the awaiting trial, but those that have been awaiting trial for over 180 days and from the date of arraignment. Now, breaking it down in terms of 180 days from the date of arraignment, that itself is quite a number of challenges, because we all know that it takes a while for the date to even get arraignment. And this is the challenge, first challenge we'll have to confront you. If it is taking about 6 months, sometimes, cases are there that 6 months, 9 months, they have not been arraigned. But I don't know about Plateau, how efficient, how speedy cases have been arraigned. But we have experience over here and in other states are arraigned. And, it's got difficulty with the issue of how many prosecutors you have with those illegal and how congested the docket of the courts to even get a date at the superior court, trial court. So that's another challenge. So, but this law is providing that it's only from arraignment, which is something flaw in itself, in my opinion, of being remanded in custody. And I would like to hear from the correctional officers how they actually deal with it and compute this, in terms of whether it's the day of being where they are secured into their custody, or they start marking days from the day of custody until the arraignment is when you start triggering your 180 days. I would like to get a clarity from you in terms of how you do it operationally. The second point, in relation to these 180 days that I want to point out, and I want to have this forum to clarify these issues, is in relation to the awaiting trial process itself. And that is why we always why we have such a workshop to say that we clarify this issue that in terms of awaiting trial. There are those awaiting trial that are in custody, which is what this speaks to. There are those that are not even awaiting trial awareness, and they sensitize the officers as well of how we are actually dealing with this issue of those category of people who seemingly are categorized under awaiting trial, but they are not actually awaiting trial. Number one is because they have not been arraigned anyway. But then when you are compiling your returns, the question is, are you adding those people who are charged under Part 32, these are under remand proceeding, those categories specifically, if I must clarify, are those suspects, they are not even strictly sensu defendants, because they have not been charged. and the police and the other law enforcement agencies are applying for further time under Part 32 of the ACJL before the magistrates